Yes. Okay, so I'll start again. It is an enormous privilege for me to be able to introduce tonight Hamlyn Lecture and Hamlyn Lecturer at Mansfield. As some of you may know, the Hamlyn Trust was created by Miss Emma Hamlyn in memory of her father, who was a solicitor and a justice for peace in Torquay in Devon. And she felt that public understanding and respect for English law and the rule of law was important, and founded this lecture series so as to extend public interest and understanding in the law. And the first Hamlyn lecturer was Lord Denning in 1949, and there have been a number of eminent legal practitioners and distinguished judges and academic lawyers giving these lectures ever since. So I'm very grateful to the Hamlyn Trust for enabling us to host the lecture in what I hope is a fitting venue, because Mansfield College, which was founded in the 19th century, was also intended to broaden public understanding and interest in ideas for those who might not otherwise come across them. And that's a mission that I think we continue in a 21st century context today. But I am also enormously proud and happy to be able to introduce as tonight's Hamlyn Lecturer, one of our own, Professor Kate O'Regan, who is a governing body fellow at Mansfield and the inaugural director of the Bonavero Institute of Human Rights, which we are proud to have in our midst, physically and intellectually and emotionally. Kate was one of my heroes before I arrived at Mansfield, and familiarity has only strengthened my admiration. Her modesty means that I'm not sure that all her colleagues in the faculty and the college always know how extraordinarily distinguished a jurist she is. But she was appointed to the first Constitutional Court of South Africa by Nelson Mandela in 1994 at only 37, the youngest judge by some margin and one of only 2 women. And she has been responsible for judgments which have reverberated nationally in South Africa and indeed internationally. I'm not going to mention the biggest and most distinguished judgments that Kate was responsible for, but one that struck a particular chord with me a number of years ago when I was a junior and I was seeking to represent a Welsh Sikh girl who was being refused permission to wear her kara at school. There was at that time a lot of English case law, mostly around Islamic dress in schools, which was pretty restrictive of students' rights. And in a search for some international comparisons, I hunted the internet and came across a judgment of the South African Constitutional Court called Pillay about a Tamil girl being allowed to wear a nose stud at court, and at school rather. And the intellectual rigor and moral clarity of that judgment was such that I knew that it would capture any judge I put it in front of, and so it did, and it became part of English law too. And so it was only after having known Kate in other contexts for many years that I suddenly realised that lovely Kate, who I knew from all these contexts, was also the distinguished O'Regan J, who had given this judgment that I so much admired, and it was one of those lovely moments putting things together. And since her retirement from the South African Supreme Court, which came ridiculously young, because she started ridiculously young and you can only do 15 years, Kate has continued various judicial roles, being fated with numerous honorary professorships and doctorates, but she is still very much full-time working academic at Bonavero and at Mansfield. And I am very delighted that she is my colleague and proud to be able to introduce her third and final Hamlyn lecture tonight. Thank you, Kate.
Well, thanks for that wonderful introduction, Helen. It's been absolutely delightful to be an ally of yours here at Mansfield, and been delightful to be at Mansfield over the last coming up 7 years, hard to believe. And I would like to thank Mansfield for being willing to host it and to host the dinner for those of you who'll be attending the dinner this evening as well. I'd also like to thank the trustees of the Hamlyn Trust, several of whom are here. I see Avram there, who have bestowed this honour upon me of delivering this year's Hamlyn Lectures. The design of the Hamlyn Lectures is something that's actually very close to my heart. The idea that law should not be something that ordinary people consider to belong in ivory towers and be beyond them is a key theme of Miss Hamlyn's legacy and of her will, and I think of the tradition of these lectures. So a kind of warm thanks to Hamlyn for that. The theme of the lectures is the courts and the body politic. And in the previous lectures, there's something slightly odd about these lectures, and that you give them in 3 different places. So most of you have no idea what the other lectures were about. But the idea is that there is an argument running through them. And I'm going to just kind of summarize that argument for you this evening. The first is that the role that courts play in modern constitutional settings has significantly expanded as a result, by and large, of the spread of written constitutions. Since the 18th century, of course, but particularly since the Second World War. And those roles that are conferred upon courts in these constitutional settings are by and large roles that are explicitly conferred by political actors for a range of reasons, of course, but it's political actors who decide that courts should be given the opportunity to play these roles. And thirdly, by and large, constitutions in many circumstances, constitutions are adopted in times of turmoil and fragility. And that means that influences why constitutions are drafted in the way they are. Most political settings are not stable, long-standing democracies of several hundred years. If you look around the 190 odd countries in the world today that have written constitutions, many of them are relatively new. Their boundaries are relatively new. Their boundaries have often been set by external forces. And the strength of both state formation and political identity is fragile. So the core metaphor that informs the lectures is this idea that courts are part of a broad body politic within their own society. This phrase, the body politic, is an old political metaphor that has been used to sustain many arguments, not all of them benevolent, over the centuries. And the use of it as a metaphor needs both explanation and justification. In these lectures, it is used to illuminate the fact that in most modern states, there are different institutions and actors that affect how the state is governed. These institutions are dynamically interdependent, just as parts of the body are, and their relationship is determined in part by constitutional design or text, but also by questions of political and legal culture, determined by many factors: history, politics, economics, and social relations. The body politic thus comprises not only the branches and institutions of state, but also what are often characterized as private institutions, such as political parties, the media, civil society, the legal profession, and even universities. The metaphor of the body politic thus captures the institutional variety and richness of modern societies, the functional differentiation of these institutions, and most importantly, their dynamic interdependence. The role that courts play in any particular body politic thus depends on the constitutional text, but also on institutional and legal culture, upon the institution's relationships and culture of the broader body politic. So finally, the series of lectures seeks to destabilize simple normative claims that it is democratically inappropriate for courts to perform expanded roles. Such claims often reflect an idealized account of how politics works in many places, indeed perhaps everywhere. And they are often coupled with a failure to grasp the fragile and precarious character of body politics at the time of constitution writing in modern societies. I don't want to replace that normative claim with a counterclaim that courts always should have important roles played upon them, or with the claim that courts always work well. That would be naive and inaccurate. But what I do want to suggest that in a time of global democratic recession, which is increasingly characterized by executive aggrandizement, claims that courts should not play important roles in bodies' politics are perhaps unwise. So in this lecture, I'm going to turn to one of the most contested aspects of the expanded role of courts, and that is human rights. On the 10th of December 1948, the United Nations adopted the Universal Declaration of Human Rights. The preamble to the declaration begins, "Whereas recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. And whereas disregard and contempt for human rights have resulted in barbarous acts which have outraged the conscience of mankind, and the advent of a world in which human beings shall enjoy freedom of speech and belief, and freedom from fear and want, has been proclaimed as the highest aspiration of the common people." In the 30 brief clauses that followed, the Universal Declaration proclaimed civil and political liberties, as well as economic, social, and cultural rights, including a right to social security, to education, to a standard of living adequate for health and well-being. 48 countries voted in favor of the adoption of the Universal Declaration, and 8 abstained, including the Soviet Union, Saudi Arabia, and my own country, South Africa, where the National Party government had been elected only months before on the basis of its manifesto to introduce apartheid. The adoption of the UDHR was an extraordinary achievement, that in the aftermath of terrible conflict and at a time of deep political disagreement, it was possible to produce a document expressing a global commitment to treating human beings equally and with respect was astonishing and momentous. You will have passed, though you may not have noticed, the striking statue of Eleanor Roosevelt on your way here tonight. If you didn't notice it on the way in, do look for it on the way out. It's on your left, just as you go up the steps. Without any doubt, Eleanor Roosevelt made a remarkable contribution to the adoption of the Universal Declaration. First, as chair of the Nuclear Committee appointed to advise on the structure and functions of the newly established UN Commission on Human Rights, and then as the chair of the UN Commission that undertook the drafting of the declaration. It may be, as Mark Mazauer has argued, that the UDHR was made possible because it did not impose legal obligations on states. Yet it nevertheless constituted, as another scholar, Andrew Moravchik, has claimed, a fundamental challenge, not just to the Westphalian idea of state sovereignty that underlies realist international relations theory and classical international law, but also, though less frequently noted, to liberal ideals of direct democracy, legitimacy, and self-determination. The post-war emergence of these arrangements has rightly been characterized as the most radical development in the whole history of international law. Of course, it was nearly 20 years before the rights declared in the Universal Declaration became legally binding on those states that ratified the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, which were adopted in the mid-1960s. Continuing your tour of the iconography of the Bonavero, when you go upstairs, you will see a photograph of Sir Egerton Richardson, Jamaica's first representative to the United Nations, who chaired from June 1964 the UN Human Rights Commission, and who was a major driver of the adoption of the treaties, overcoming the resistance to their adoption from both the West and the Soviet Union and its satellite states. The excellent photographic portrait of Sir Egerton hangs in the Bonavero, and I often, it doesn't at the moment have a name telling you, and I often ask human rights experts when they come in, I say, you know, come to a conference, I say, we've got a quiz at the end of this conference, somebody's got to tell us who that is. And nobody ever knows. And it's just an indication of how the fact that actually the international covenants were really a project of the global South, one of the first things that happened in the post-colonial era, has actually been forgotten already. So the two covenants are together known as the International Bill of Rights, and their adoption was an extraordinary achievement. Today, the International Covenant on Civil and Political Rights has 171 ratifying states, and only 20 countries have not ratified it at all. And the International Covenant on Economic, Social, and Cultural Rights has 168 state parties. In addition to these two great covenants, of course, there are regional human rights treaties. The European Convention on Human Rights, adopted in 1950, which now has 47 member states, the American Convention on Human Rights, adopted in 1969 with 24 member states, and the African Charter on Human and People's Rights, adopted in 1986, which has 53 signatories. In a recent article, Zachary Elkins and Tom Ginsberg have shown that the Universal Declaration has had a significant and continuing impact on the drafting of domestic constitutions in the decades that followed its adoption. They conclude that the Declaration has been influential in the drafting of domestic Bill of Rights, noting a distinct pattern whereby rights in the Declaration were reproduced in domestic constitutions increasingly in the years following its adoption. A significant number of constitutions expressly reference the Universal Declaration. For example, the preamble to Egypt's 2014 constitution states that we are drafting a constitution that paves the way in the future for us and which is in line with the UDHR, which we took part in and which we approved. Elkins and Ginsberg notably speculate on the basis of their study that if the UDHR had not been adopted, national constitutions would likely contain fewer rights, and in particular, a smaller core of consensual rights, and that the societies governed by these rights today are very different places to live because of the UDHR. So this series of lectures is interested in key questions relating to the way courts function in bodies politic across the globe. The first is largely an empirical one, primarily addressed in the first lecture. Just what is it that courts are doing in modern constitutional settings? The answer I suggested is that written constitutions have conferred an expanding and varying array of functions on courts over the last 200 years. And one of those functions includes the adjudication of human rights. The second question, which was addressed in the second lecture in relation to the executive branch of government and to be addressed this evening in relation to human rights, is whether it is possible to make general normative claims about the roles that courts should play in modern constitutional settings. The answer to this question in relation to the executive branch was a cautious yes, although I asserted that the precise role courts play will need to be adapted to the constitutional framework and culture of a given society. In speaking of human rights, this lecture will conclude with a perhaps less cautious yes in relation to the adjudication of rights, although it will echo the caveat in the earlier lecture that the role courts can and should play in a given body politic needs to be developed within the particular constitutional framework of that country, including the political and legal culture. So this lecture will explore three questions. First, what role do domestic courts play in adjudicating rights in different constitutional settings? Secondly, what role should courts play? And thirdly, what conclusions can we draw from these questions for current debates in the United Kingdom concerning a possible repeal of the Human Rights Act and even the withdrawal from the European Convention on Human Rights? International human rights law recognizes that constitution making is a sovereign process that enables the people of a particular territory to determine their structures of government. Thus, international human rights law does not dictate to countries how to structure their constitutional framework. It simply requires countries to meet their international human rights law obligations through whatever constitutional structure they establish. Today, most countries have written constitutions. Yet there is a wide array of constitutional systems and practice across the different bodies politic in the world. That array means that the way in which international human rights treaties are domesticated varies considerably. And this variability is not inconsistent with international human rights law, but it is relevant to seeking to answer the question, what role courts play in the protection of rights. I identify 8 characteristics of constitutional frameworks that shape how courts adjudicate rights. And this is only talking particularly about the constitutional framework. There's substantial variability in these 8 elements. The first is a question of constitutional design, and it's whether there is a written constitution and whether it contains a Bill of Rights. At the time the Universal Declaration was adopted, only a handful of countries had adopted constitutionally entrenched Bill of Rights. But that has changed in the last 3/4 of a century. And now more than 80% of countries in the world have written constitutions that contain a justiciable Bill of Rights. Yet there remain several countries that do not have constitutional bills of rights. Many of them that do not have constitutional bills of rights are systems based on parliamentary sovereignty. And in some, but not all, a legislative Bill of Rights has been enacted to protect rights. New Zealand is a good example. In 1990, its Bill of Rights was adopted in an act of parliament, and it's based almost entirely on the International Covenant on Civil and Political Rights. It empowers courts to determine whether delegated legislation and the conduct of state administrators is consistent with the rights in the Bill of Rights, but it does not empower courts to strike down as invalid legislation that is inconsistent with it. It's similar, of course, in design, but not identical to the United Kingdom's Human Rights Act, which I'm going to come back to in a little while. I would start, however, by saying that the UK Human Rights Act, in my view, deftly accommodates both the doctrine of parliamentary sovereignty and the principled commitment to the protection of fundamental rights by expressly authorizing courts to declare legislation that is incompatible with rights to be so, but by providing that such declarations have no force unless Parliament acts upon them. So that's the first question. Is there a written constitution, and does it contain a Bill of Rights? The second is what rights are protected. Some rights are nearly always protected, such as a general right to equality, which is entrenched in 97.8% of all written constitutions, and the right to freedom of expression, which is protected in 94% of constitutions. But other rights are not common at all. The right to bear arms, for example, famously entrenched in the US Second Amendment, has never been widely accepted in the world. Only 9.5% of constitutions contained it in 1945, a proportion that has now dropped to fewer than 0.5% of constitutions. Overall, the rights in the Universal Declaration, and particularly civil and political rights, are among the rights that are most commonly protected. But there are a significant number of constitutions that also protect economic, social, and cultural rights. Moreover, the Universal Declaration has not served as a barrier to novel rights. The right to a healthy environment, for example, which was not protected in the Universal Declaration, although just last year, the Human Rights Council passed a resolution recognizing that access to a healthy and sustainable environment is a human right, was protected in only 9.5% of constitutions in 1945, but it's now found in 70% of constitutions. So the second characteristic then is what rights are protected. And the third, the lawyer's question, is how rights are formulated. And that also differs considerably. Take, for example, the right to equality mentioned in Article 7 of the Universal Declaration, which states that all are equal before the law and entitled without discrimination to equal protection of the law. Article 14 of the European Convention, drafted shortly after the Universal Declaration, is different. It states that the enjoyment of the rights and freedoms set forth in the Convention shall be secured without discrimination on any ground, and then it lists a series of grounds: race, sex, color, language, religion, political or other opinion, national or social origin, property, birth, or other status. The inclusion of lists of prohibitive ground has become much more common since 1950. Sometimes it's a closed list, so new grounds of discrimination may not be added, and sometimes it's open, as in the case of Section 15 of the Canadian Charter, adopted in 1982 and which came into force in 1985. And it states that every individual is equal before and under the law and has the right to equal protection and equal benefit of the law, which was a Canadian novelty, without discrimination, and in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. So the Canadian Charter is different again to the European Covenant, the European Convention. And when you look at different texts of different national constitutions, you find equality clauses vary, as do many of the different rights across the constitutional settings. The fourth way in which constitutional frameworks vary is in relation to how they interact with international human rights law. There is, of course, the well-known monist-dualist divide, in which monist systems consider that international human rights law, once ratified according to the constitution of that particular state, becomes law in that state. Dualist states recognize that although once there have been the international treaty has been ratified appropriately, it imposes international obligations upon the state, it doesn't become binding in domestic law. Now, this is a divide which is much less sharp than often assumed, but there remains significant variability on how monist and dualist systems respond to their international human rights law obligations. Another way in which the relationship with international law varies can arise from interpretive provisions. Famously, the South African Constitution, although considered to be a dualist jurisdiction, obliges courts when interpreting the Bill of Rights to interpret it, to consider international law. Notice it says consider, not apply international law. The South African courts have in fact read international law in this interpretive clause very broadly to include matters that are not only treaty obligations that South Africa bears in international law, but also what is often referred to as soft law. And finally, of course, another important aspect of international law's relationship with domestic rights adjudication depends on whether a country is a member of a regional human rights treaty system, such as the European Convention on Human Rights, the Inter-American Convention, or the African Charter. These three regional systems all have courts that hear cases brought by individuals alleging the infringement of their rights by one of the states that is a party to the relevant treaty. And the relationship between the regional human rights systems and domestic courts differs across the three systems and across the countries within the systems and over time. I'm going to come back to talk a little bit more about the relationship between the UK and the European Convention on Human Rights towards the end of the lecture. Fifth, and importantly, bills of rights, whether constitutional or legislative, provide differently for the limitation of rights. Under the European Convention, for example, some rights are referred to as absolute because the Convention does not contemplate their limitation. Absolute rights under the ECHR include the right to be free from torture and the right not to be held in slavery or servitude. Other rights under the ECHR expressly contemplate limitation, and they have limitations clause written into them, and they're generally referred to as qualified rights. However, many domestic constitutional systems do not acknowledge a distinction between absolute and qualified rights. Under the Canadian Charter, for example, all rights and freedoms are subject to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Similarly, Section 5 of the New Zealand Bill of Rights Act provides that rights and freedoms in the bill may be subject only to such reasonable limits prescribed by law as can be demonstrably justified. And similarly, Section 36 of the South African Constitution contains a general limitations clause in slightly different terms to Section 1 of the Canadian Charter, but the basic principle is the same. So how a charter or a constitution provides for limitations impacts, in fact, on the conception of rights that underpins the charter. If there is a general limitations clause, there is a recognition that rights are not automatically trumps, to use Ronald Dworkin's famous phrase. A sixth difference in how rights are protected relates to whether a Bill of Rights is amendable, and if so, how easily. The question arises in relation to constitutional Bill of Rights, as legislative Bill of Rights are ordinarily amendable by ordinary legislation. Amendability is important, as it's one of the ways in which a legislature can respond to a court decision concerning rights. And in some legal systems, the possibility of amendment of bills of rights is commonly considered and commonly implemented. In others, even if amendment is possible, it rarely happens. This is an indication of the fact that the text is not determinative of how, in fact, rights are protected. Political and legal culture is important here too. And in some constitutions, rights may not be amended at all. Take Namibia, for example. Its Bill of Rights is effectively an eternity provision, which is not subject to any amendment. A seventh difference is that when courts may determine challenges to legislation based on rights. So, for example, in some cases, it's only members of the legislature that can challenge legislation as being inconsistent with the Bill of Rights. Until 2010 in France, for example, the Conseil constitutionnel could only review legislation for constitutional compliance once it had been adopted by the legislature, but before it had become law, and if it was referred to the Conseil by members of the legislature. That has since changed, although the Constitution changed to allow the Conseil to entertain requests from litigants. In fact, the Conseil has read that down very narrowly and largely continued in the exercise of its own legal culture with a practice that had existed before. In other constitutional settings, the constitution or legislation requires challenges to be brought by people who are directly affected by the legislation under challenge. The United States is a classic example of that. But then again, there are systems such as India, Colombia, and South Africa, all of which allow people to act on behalf of others who are affected, but who are for one reason or another not bringing the challenge. So all of these questions about who can bring challenges changes the role that courts play in a particular setting. And finally, of course, what remedies courts can order in the case of a finding of a breach of human rights affects the role courts play in protecting rights. Here, there is a difference between domestic systems and regional systems, but there are also many differences within and between domestic systems. Legislation that protects a particular right, for example, take an example like data privacy, might well have very specific remedies written into the legislation. General bills of rights, whether legislated or constitutional, may have general remedies provisions, which will ordinarily include public law forms of relief, such as injunctive and mandatory relief. And in some jurisdictions, a range of novel forms of structural injunction have been employed, in which courts direct government defendants to take action to remediate rights infringements. Damages are another form of relief. So these 8 elements, where the rights are protected constitutionally or legislatively, which rights are protected, the precise textual formulation of rights, the relationship between international law and domestic law, whether and how rights may be protected, how amendable rights protections are, in what circumstances courts can adjudicate infringements of rights, and what remedies are available, all determine the role courts play in protecting rights and lead to significant differences across different constitutional frameworks. So that's really just to illustrate how varied the practice is. It's sometimes very easy to just assume that what another country is doing looks like what your country is doing. And in fact, both text and practice and culture can often mean that it doesn't look at all alike. I want to turn now to the second big question, which is there a normative argument to be made that courts should be conferred with a role to protect rights? It has been a key theme of these lectures that we should be circumspect about making general claims about the role of courts in the body politic that apply across all societies, regardless of their different constitutional frameworks, different histories, and different legal and political culture. Yet, in one important respect at least, it seems clear that this question should be decisively answered in the affirmative. For in all modern societies, legislation is a key mechanism for the protection of rights. Codes of criminal procedure, legislation regulating primary and secondary education, electoral laws, are all examples of legislative mechanism for the protection of human rights. Courts must interpret and apply this legislation as they do all law, and in doing so, they must protect and fulfill human rights. The more contested and difficult question is whether it can be claimed that courts should be conferred with a broader responsibility for the protection of rights. There are 2 key mechanisms discussed earlier whereby courts could be given such a responsibility. The first is a constitutionally entrenched Bill of Rights, and the second is a legislated Bill of Rights. Both contain a catalogue of rights. The main difference is that a legislated Bill of Rights does not bind the legislature, but constitutional bills of rights ordinarily do. Scholars have termed the form of review under legislative Bill of Rights weak form review to distinguish it from strong form review under entrenched Bill of Rights. By and large, the primary criterion is whether courts can strike down legislation. This distinction may not always be helpful, as Aileen Kavanagh has pointed out. She notes that the distinction detaches design from practice, which echoes a lot of what I've said, that in order to understand exactly what's going on in a constitutional setting, you need to do more than just look at constitutional text. You need to look at practice and culture. And this distinction between weak and strong form review may obscure how judicial review actually works. But I would like to start with the key and most difficult question. Should courts be conferred with the strong form judicial review power to declare legislation that is inconsistent with the Constitution invalid, as most written constitutions now do? There's a robust and perennial debate that strong form judicial review is inconsistent with democracy because it affords courts the power to declare legislation enacted by a democratic legislature invalid. In his elegant and influential article, Jeremy Waldron argued that if four key assumptions hold, strong form judicial review is inappropriate as a mode of final decision-making in a free and democratic society. He gives two reasons for this. First, he argues that judicial review distracts from core political disagreements about rights and focuses attention on precedent, text, and interpretation. And secondly, he argues that judicial review disenfranchises ordinary citizens and brushes aside cherished principles of representation and political equality in the resolution of disagreements about rights. His argument at the level of democracy is intuitively attractive, but it's important to examine its four founding assumptions, which in my view undermine the reach and cogency of his argument. Waldron stipulates that his argument will obtain if A, democratic institutions are in reasonably good working order, including a representative legislature elected on the basis of universal suffrage. B, judicial institutions are also in reasonably good order and are set up on a non-representative basis to hear and adjudicate disputes and uphold the rule of law. C, if there's a commitment on the part of most members of the society and most of its officials to the idea of individual and minority rights. And D, if there is persistent, substantial, and good faith disagreement about rights. The focus there being on the idea that there's a recognition that good faith disagreement about rights is legitimate. So for the argument to hold, these conditions need to exist not only when a constitutional framework is adopted, but they also need to be likely to continue to exist in the future. For if that is not the case, it will be too late then to fix your constitutional system. There are not many societies in which these four conditions hold, and probably none in which one can be certain that they will continue to exist. As importantly, however, given the circumstances in which most constitutions are adopted, the time of constitution making will often be the least propitious time for the likely presence of Waldron's four conditions. In the first lecture of this series, I explained the circumstances under which modern constitutions have generally been adopted. These are often politically and socially fraught. Many constitutions are peace agreements in post-conflict situations, or are adopted at the ends of imperial or colonial rule, or at the end of a war, or in times of transition from military or authoritarian rule. In such circumstances, national identity is often fragile and state formation incomplete and vulnerable. Democratic and judicial institutions will often be untested or undergoing transformation, and it will not be possible to say whether they are or will be, as Waldron puts it, in good working order. And again, in these situations, it will be often difficult to assess whether there is a deep-seated commitment to upholding individual and minority rights, and whether disagreement about rights will be reasonable or in good faith. The moment when constitutions are made will thus rarely be a time when Waldron's four conditions will be clearly manifest. Of course, it doesn't follow that if his conditions do not hold, then it will necessarily be appropriate to confer upon courts their power to exercise strong form judicial review. The absence of his conditions will simply mean that robust and good faith protection of rights by the legislature may not be reliable. It is that very uncertainty that may lead constitutional drafters to favour strong form review. Indeed, as explored again in my first lecture, the decision to confer strong form review powers upon courts is often a political decision made at the time the Constitution is adopted by political actors. In an early influential study, Tom Ginsberg argued that politicians often see strong form review as an insurance policy that will provide protection should they lose power in the years ahead, assuming that strong form review may limit the ability of subsequent leaders to change the rules of the game in their own favour. The fact that political leaders opt for strong form review may thus be an indicator that they are not confident that Waldron's 4 conditions will hold in their body politic, and they seek to provide some guarantee that the constitutional framework will endure. There is another argument for strong form judicial review that warrants consideration. The genesis of this argument is in a footnote to a 1938 decision of the United States Supreme Court called Caroline Products. The case was decided not long after a constitutional crisis concerning the US Supreme Court was narrowly averted. The crisis arose because in the early decades of the 20th century, the US Supreme Court had delivered a series of decisions overturning social welfare legislation enacted by federal and state governments. This series of decisions has been named after a 1905 decision, Lochner versus New York, in which the court held that the New York legislation stipulating maximum hours of work infringed the 14th Amendment of the Constitution. The line of decisions that followed Lochner frustrated President Roosevelt, who was seeking to implement his New Deal policies in the 1930s. And in February 1937, President Roosevelt published a Judicial Procedures Reform Bill, which proposed to add more judges to the Supreme Court. Many of you will have known that these debates are arising again in the United States. Just 2 months after the bill was published, the US Supreme Court issued a decision in which one of the judges who had previously supported the Lochner line changed his position to support those who had opposed it. And this moment is often referred to as the switch in time that saved 9. Issued just a year after that, Caroline Products concerned a constitutional challenge by a company accused of infringing a legislative scheme that prohibited the interstate shipment of skimmed milk compounded with other fats to resemble milk. The applicant argued that the legislation was unconstitutional because it exceeded Congress's power to regulate interstate commerce and because it infringed the Fifth Amendment. But the court rejected the challenge. In doing so, the court argued that the evidence received by Congress when adopting the legislation was adequate. But even in the absence of evidence that was adequate, the court said it would ordinarily presume legislation to have a rational basis. This was a feather-light touch approach to strong form judicial review, very different to the reasoning that had been prevalent in Lochner. But footnote 4 of Caroline Products, probably the most famous footnote in constitutional history, carved 2 possible qualifications to this light touch approach. These qualifications were formulated as follows. It's unnecessary to consider whether legislation which restricts political processes, which could be expected to bring about the repeal of undesirable legislation, should be subjected to more exacting review. So the question whether the restriction on political processes should be subjected to more exacting review, nor need we inquire whether more exacting review should be directed at statutes that are infringing the rights of particular religious, national, or racial minorities. The footnote thus suggested that legislation aimed at restricting political processes or directed at insular minorities might warrant more scrutiny. This footnote formed the basis for a very powerful defense of strong form judicial review launched by US law professor John Hart Ely. Ely argued that strong form judicial review is legitimate where it protects the political process from inappropriate interference by political incumbents and where it protects minority groups from discrimination. Ely's 2 conditions for the legitimacy of strong form review match two of Waldron's conditions. Ely's argument is that courts should act to preserve the good working order of the democratic institutions of government, similar to Waldron's first condition, and secondly, that courts should protect vulnerable minorities, again, similar to Waldron's third condition. He therefore carves out a legitimate role for constitutional review to ensure that Waldron's conditions are protected. Ely's process-based account of strong-form judicial review is enjoying a renaissance in the current global context, where I outlined in the first and second lectures, we're seeing a pattern of democratic regression across many democracies. Stephen Gardbaum has argued that the central insight of this political process theory is that protection of a system of representative democracy against erosion by elected representatives cannot be left exclusively in the hands of elected representatives. And he argues that Ely's approach should be expanded to include all processes through which public power is allocated. This political process account of strong-form judicial review is intuitively attractive. But as with many intuitively attractive accounts, its greatest challenge lies in the details of its application. In a thoughtful article, Michaela Heilbronner concluded that when courts intervene in democracy, there is a risk that they may do more harm than good. If we're to develop a workable and defensive political process theory, we will need to do more work than has currently been done. So I'd like to conclude this discussion with a summary of how to answer the question whether courts should be conferred with the power to protect rights. First, I conclude that there can be no doubt that courts in modern democracy should be engaged in protecting human rights where those protections are contained in legislation directed at protecting rights. It's an important mechanism for the protection of rights in all jurisdictions. Secondly, the enactment of legislative bills of rights confers courts with the role of protecting rights. Even those firmly opposed to strong-form judicial review generally accept that weak-form review is not incompatible with democracy. Richard Bellamy, a leading opponent of strong-form constitutional review in the UK, takes the view that the UK Human Rights Act strikes an appropriate balance between protecting the democratic role of Parliament and ensuring the protection of rights. Third, strong-form judicial review for rights raises more difficult questions to answer for all societies in all circumstances. I have explained that given the circumstances in which most modern constitutions are written, it will rarely be certain that Waldron's 4 criteria, upon which he bases his core case against judicial review, will exist at the moment of constitutional entrenchment. Uncertainty about whether democratic institutions will work well, whether there will be an enduring commitment to individual and minority rights, and whether disagreement about rights will be articulated in good faith, will often lead constitutional drafters to concluding that strong-form judicial review is appropriate for their constitutional design. And where a constitutional text does confer strong-form judicial review upon courts, courts are obliged in good faith and with fidelity to law to exercise their powers. Of course, in practice, courts' performance of their role may be less than ideal. And where courts get things wrong in a strong-form system, it is often hard to put things right. So in these circumstances, no general claim that strong-form judicial review is always appropriate can be made. Yet we might say that the case for it is at its strongest in the following circumstances. In divided and unequal societies in which groups might be at particular risk of majority abuse, where the courts are seen as independent, impartial, and competent, where there's an independent and competent legal profession and an engaged legal academy, where good training is provided to lawyers, where there's a constitutional text that is reasonably capable of amendment and adopted following a fair and inclusive democratic process in which the power of judicial review is explicitly provided, and which adopts a 2-stage model for the adjudication of rights, which recognizes that rights may be limited where government can show that it is reasonable and justifiable to do so. So those are my conclusions on whether courts should adjudicate rights. And now I want to turn briefly to the UK Human Rights Act debate. The current government in the United Kingdom has repeatedly expressed its concern about the role that courts play in protecting rights in the United Kingdom. The Human Rights Act gives domestic effect to the rights contained in the European Convention, which was drafted not long after the adoption of the Universal Declaration. Between 1950 and 1998, when the Human Rights Act came into force, British courts had no jurisdiction to entertain claims based on the European Convention, and British people who wished to rely on the rights in the European Convention had to go to the European Court on Human Rights in Strasbourg. The Human Rights Act changed that. The white paper which introduced it spoke of bringing rights home and ensuring that British courts could, at last, adjudicate the rights in the European Convention. Yet, the adoption of the Human Rights Act did not settle ongoing controversy about the role of the European Convention in Britain. As Lord Carnwath, a former judge of the Supreme Court, observed in a recent lecture, "I cannot remember a time when the place of the European Convention in our law has not been the subject of active debate." The key operative provisions of the Human Rights Act are that people who allege an infringement of one of the rights may now approach British courts for a remedy. The Act provides that when courts decide questions concerned with human rights, Convention rights, they should take into account the jurisprudence of the European Court of Human Rights. When the Lord Chancellor, Lord Irvine, introduced the bill in Parliament, he stated that the Act would permit UK courts to depart from Strasbourg decisions, and British courts have recognised that although ordinarily they should follow Strasbourg, if there are strong reasons to do so, they may depart. Thirdly, the Act provides that when interpreting legislation, British courts should, so far as possible it is to do so, interpret legislation in a manner that will give effect to Convention rights. The UK courts have taken a broad approach to this mandate, recognising that at times it may require courts to depart from the unambiguous meaning of the legislation. This has been controversial, but the interpretive provision in some senses is the twin of the fourth key operative provision in the Act, which provides that when a court concludes that a legislative provision cannot be read in a manner compatible with the Convention rights, it may choose to issue a declaration of incompatibility. As I said before, the declaration does not affect the validity of the provision, but it simply draws the issue to the attention of Parliament. Declarations of incompatibility are infrequent. In the 20 years between 2000 and 2020, there had been issued only 43 times. 9 of those have been overturned on appeal. 5 related to provisions that had already been amended by the time the declaration was made. 15 have been addressed by primary or secondary legislation, and a further 8 by remedial order. And the remainder are either subject to appeal, have been addressed in another way, or still under consideration. Aileen Kavanagh, in her forthcoming book, has conducted a conclusive and a careful analysis of all these declarations of incompatibility. She says that of all of them, only 4 generated political debate and resistance. She also concludes that parliamentary committees have generally treated declarations as authoritative judicial rulings they are obliged to respect, and that the response has been predominantly collaborative rather than conflictual. In December 2020, the then Lord Chancellor and Secretary of State for Justice, Robert Buckland, announced the establishment of an independent review into the Human Rights Act to be chaired by retired Court of Appeal Judge Sir Peter Gross. The terms of reference requested the panel to explore 2 key themes: the relationship between the British courts and the European Convention, and the impact of the Human Rights Act on the relationship between the 3 branches of government in the UK, the executive, the legislature, and the judiciary. A firm premise of the review was that government was not contemplating withdrawal from the European Convention, or at the time, the repeal of the Human Rights Act. The review was focused not on the substantive rights in the European Convention, but on how the Human Rights Act worked. The panel adopted an open and inclusive and comprehensive process, calling for evidence and responses from individuals and organizations, hosting 14 online roundtables, as well as 7 online roadshows facilitated by universities. Its careful and comprehensive report was issued in October 2021. By and large, the review concluded that the Human Rights Act was working well, and it recommended just a few modest changes to clarify and refine it. On the same day that this report was published, the government issued a consultation paper in which it invited comments on proposals to revise and replace the Human Rights Act with a UK Bill of Rights. The consultation raised 29 questions for comment. As Sir Peter Gross, the chair of the independent review, observed in his evidence to the Justice Committee in Parliament in February 2022, the consultation was not a response to the panel's report. It appeared to be an entirely different project. That it was became clear when, following the consultation paper, the government published a draft Bill of Rights bill on the 22nd of June this year. The draft bill proposed the repeal of the Human Rights Act and the enactment of a legislative Bill of Rights. The government sought to fast-track the bill through Parliament. Just over a week after the first reading of the bill, the acting chair of Parliament's Joint Committee on Human Rights, a committee responsible for scrutinising government's human rights record, comprising members of both the Commons and the Lords, wrote to the Lord Chancellor to express their concerns, noting that the inquiries conducted by the Joint Committee had led them to conclude that the Human Rights Act is functioning as intended, enabling human rights to be enforced effectively in the UK, with little recourse required to the European Court. The letter drew attention to the evidence the committee had received from Judge Robert Spano, then President of the European Court of Human Rights, who noted that since 2017, the United Kingdom, of all the 47 member states of the Council of Europe, had the lowest number of cases pending before the court. Between 300 and 415 applications against the UK were filed between 2017 and 2021. That is, between 0.04 and 0.06 applications per capita. In January 2021, there were in total 62,000 cases pending before the European Court, of which only 124 related to the UK. Judge Spano noted that the vast majority of cases brought against the UK are dismissed by the ECHR as inadmissible. In 2020, for example, the court decided 284 cases in which the UK was a respondent. It dismissed as inadmissible 280 of these, finding no violation in one case of the remaining 4. A friendly settlement was struck in another, and found against the UK in only 2 cases. The second reading of the draft Bill of Rights was postponed in early September after Liz Truss became Prime Minister following the leadership contest in the Conservative Party over the summer. And the minister responsible for its introduction, Dominic Raab, left the cabinet at that stage. However, following the election of Rishi Sunak, politics in the UK is even more interesting than South Africa nowadays. As Prime Minister last month, Dominic Raab once again returned to the cabinet, and it has been announced that the Bill of Rights bill will once again come before Parliament. The current Bill of Rights bill does not propose that the UK withdraw from the European Convention, yet there's little doubt that the question of the UK's continued membership of the Council of Europe and its ratification of the Convention remain a contested issue within the Conservative Party. During the public debates at the time of the leadership contest in the summer, several senior members of the Conservative Party suggested that the way forward was to withdraw from the European Convention. As an outsider and someone who comes from a post-conflict society in which the entrenchment of human rights is by and large an uncontroversial matter, the debate in the United Kingdom about its membership of the European Convention is both puzzling and disquieting. The debate is puzzling because the Human Rights Act in Britain represents an adept accommodation of 2 conflicting principles, democracy and respect for human rights. And even those political theorists most skeptical of constitutional review appear to respect the balance in the Human Rights Act. Opposition to it, therefore, cannot easily be explained as a democratic concern. Parliament remains sovereign in the law that it chooses to make and unmake. It seems to me that much of the skepticism concerning the promotion of human rights in Britain is thus not properly understood skepticism about the design of the Human Rights Act itself, and that is disquieting. For it appears to be skepticism about the regional and international project which seeks to ensure the protection of human rights for all, which I described at the outset of this lecture. Today, the divide between illiberal and authoritarian societies who in their deed scorn the international human rights project, and those societies that remain committed to the post-World War II vision of a commitment to international human rights as the foundation of freedom, justice, and peace in the world, is deepening. It is a worrying time for societies who are in word committed to human rights to be indeed wavering in their commitment to the global protection of human rights. In concluding, these lectures have suggested that the role courts play in modern body politic has expanded significantly as a result of the writing of modern constitutions. and that constitutional writing takes place in difficult and contested circumstances. And it is these circumstances which have led to the expanded role of courts. That expansion has often been driven by political actors seeking to ensure the endurance of a constitution in circumstances of fragile state formation and political identity. In understanding the role courts play in any constitutional framework, we need to recognize that courts are institutions within the broader body politic, which comprises not only the branches and institutions of the state, but actors such as political parties, the media, and civil society. How courts perform the roles conferred upon them by a constitutional framework thus depends both on the legal and institutional culture of the court, but also upon the institution, relationships, and culture of the broader body politic. Given the factors that underpin the expanded role of courts in modern societies, the factors that determine how courts function, and the spreading global pattern of democratic decline, responding to the expanded role of courts with a simple normative claim that it is democratically inappropriate for courts to perform these roles isn't satisfactory. Such claims often rest on an idealized account of how politics works, coupled with a failure to grasp the fragile and precarious character of the body politic in many modern societies. Insofar as the protection of human rights is concerned, courts will always have an important role to play, although the precise boundaries of that role will vary. In the end, it is always important to remember that courts are not the only institution that bears the responsibility of rights. If the legislature and executive turn against the protection of rights, the ability of courts to assure them will be severely diminished, if not extinguished. The assertion of the Universal Declaration that the recognition of the equal and inalienable rights of all, with a foundation of justice, peace, and security in the world, remains as timely and important in 2022 as it was in 1947. Courts have a role to play in the protection of rights, but it is not their responsibility alone. It is a responsibility that should be borne by all of us in the body politic. Thank you.